Namaste, good morning. Welcome to 151 episode of AAA Weekly Webinar Series. As we have already announced that today would be the third and final part of cross-border insolvency and what the government has done so far, how it is being implemented. That is what we have discussed in episode part 1, part 2 of this cross-border insolvency. When we see that in this particular uh, episode, we are going to discuss again the rules made by the committee and also the what is the discussion in the parliamentary standing committees. We actually have discussed in the past that the uh, recommendations of the Insolvency Law Committee has been to adopt UN model law on cross-border insolvency. We have also seen that it is recommended by the ILC, the Insolvency Law Committee, uh, that there should be a special bench of the adjudicating authority, that means NCLT, handling cross-border insolvency matters. Also, the adjudicating authority in India should independently assess the central administration, that is 𝐄𝐚𝐚𝐢𝐥. The central government will also be empowered to prescribe a list of indicative factors to guide adjudicating authority for the purpose of determining center of main interest, that is 𝐄𝐚𝐚𝐢𝐥. Also, we discussed in the earlier part 1 and part 2 that in India it is called resolution. However, in the UN Citrol model, it is called reorganization. And also on the public policy. On the public policy, we have done a little bit of initial discussion, and we will be discussing in detail today. And also, we will discuss the foreign representatives, whether they would be having access to Indian courts, or even the uh, Indian representatives will have the access to foreign courts or not. Also, because in India, the foreign lawyers are not uh, the foreign lawyers are not supposed to practice, they are not allowed to practice. So that is the only difficulty. However, we also discussed that when we talk about foreign representatives, we only talk about the liquidators and the administrators or the resolution professionals who are appointed on the company to take control and custody on the assets. And also, we actually have seen that the recognition of foreign proceedings in India, and then interim and main relief. So that is what we actually have to see. It's about like today, we will start this subject from interpretation of public policy. Interpretation of public policy, in fact, it has a lot of international jurisprudence. Although the domestic jurisprudence is not there, but there is a domestic interpretation of the Insolvency Law Committee and the uh, Parliamentary Standing Committee. So they actually have recommended, there are some concerns about the public policy, and we will discuss, and today we will start from the public policy. When we see this international jurisprudence, we have the examples of US court, various decisions where the US court actually had protected their own companies or the assets in their own countries. And in such cases, it can be the US court, in fact, has passed various orders where they have seen that the automatic stay order of a US court by a foreign insolvency proceedings, by citing that it is against their public policy. It is in violation of the US privacy or criminal law, or even it is the detrimental effect on the technological innovation in the US due to the disregard to the US patent licensing agreements. In domestic interpretation, we have also seen that the report suggests that adjudicating authority can draw upon Indian legal principles and precedents to determine what constitute the public policy. And in fact, the committee recommended that the central government uh, should be involved in determining whether it is a public policy concern or not. So that is what is regarding the public policy. And in fact, we discussed that Article 5 of the model law, which allows domestic insolvency representatives in the enacting country to access foreign courts or act in foreign countries concerning insolvency proceedings. Now, the committee concluded, since the Indian law currently does not prohibit Indian insolvency professionals from acting in the foreign courts, so therefore Article 5 should be included in the draft Part Z, because we discussed that there is a draft part which is called Z, and that will be part of the Insolvency and Bankruptcy Code and subject to regulations made by IBBI. So therefore, the conditional the committee also recommended that the Article 7, which is the additional assistance under the other laws and interpretation of the model laws, so that also they should align with the model laws. Now, I also would like to say that, like in case a foreign company undergoes insolvency proceedings in its home country, and those proceedings are recognized under the model law in another country, the foreign insolvency decision may have the same legal impact as if it had been initiated in the recognizing country. So that is what is the Article 5. And also the court will allow freezing assets of the debtor based on the principles which is mentioned in the model law. Also, it says that the Article 7 ensures that such assistance remains available. Assistance means the assistance which is in the other laws, that should also be available. Like when we say that we have to take assistance of police, so that other laws, that police should assist the foreign representative for taking control and custody of the assets belonging to the corporate debtor. And therefore the foreign representatives should be able to approach Indian courts directly, and they should not be required to go through the diplomatic authorities. And even for the purpose of the documents, whatever documents are being submitted to the Indian courts, there should not be any process of apostolization or notary public authentication. That should not be required unless there is a doubt and unless this adjudicating authority specifically says that this needs further authentication. So then when we let us now discuss about the access to foreign representatives. When we talk about access to foreign representatives, my belief is that we are only talking about the uh, we are only talking about the liquidators or resolution professionals or the administrators, as it is called in overseas jurisdiction. That is what is called as a foreign representatives. It is not considered as the lawyers should not be considered as a foreign representatives. So the foreign representatives, as far as the insolvency law is concerned, is restricted to the liquidator, RP, or the administrator, whatever bankruptcy trustee, whatever it is, it may be called, but a person who has been empowered by the court to take control and custody of the assets and businesses of the corporate debtor or the debtor. Now, the model law says it grants foreign representatives direct access to courts in the enacting country to seek remedies related to the foreign insolvency proceedings. That means that in his capacity as liquidator or administrator or as RP or the bankruptcy trustee, you may call it any name, in that capacity, he can file an application to the other country and seek the access or control on the assets of the debtor or the corporate debtor. That is what is the access to the foreign representatives mean. Like uh, as we have read that the countries like UK and Singapore have adopted this provision as it is. The US requires the recognition of the foreign proceeding before granting such access. So in our episode 2, we discussed that the in some countries, first of all, they would recognize the foreign proceedings in their own country, and then they will start giving the reliefs or they will start giving the direct access. Now, model law suggests that the direct access should be given to the foreign representatives. However, the US actually gives the access only after US recognize the foreign proceedings in the country. So there are some countries they would recognize first and then they will give all the reliefs. And there are some countries they would, without even recognizing, they would give access to foreign representatives, and also they will give some interim reliefs that we will study in the subsequent slides. Now, the challenges in India that we committee felt that the Indian law currently does not allow foreign lawyers to practice in India. According to me, this is actually limited to the administrators, liquidators, RP, or the bankruptcy trustee. It is not applicable to the lawyers. The Indian lawyers can be engaged by foreign administrators. Therefore, in fact, it is suggested by the law by the committee that the foreign representatives could be treated as a separate class of professionals, similar to insolvency professionals, and may not face legal barriers. Like they can actually be considered as a separate professionals, and the IBBI will in fact draft specific rules and regulations for them. The committee also recommended that the central government should specify the extent and manner of access for foreign representatives through subordinate legislations. No, what are the subordinate legislations? It can be rules made by the central government, or it can be regulations made by the IBBI or the regulator. The Insolvency Committee also proposes that the following options may be considered. One, that recognizing foreign representatives as a distinct class of professionals, or facilitating access through domestic insolvency representatives. These two options were given. However, in USA, it is the recognizing foreign representatives as a distinctive class of professionals. This is what the committee says the that can be the option. One, that recognizing them as a distinctive class of professionals, and IBBI will first of all empanel them. And in fact, the rules have also been made for this. The fee of 10,000 has also been prescribed for this, and this probably is going to be acceptable at the when finally it is getting implemented. Then facilitating access through domestic insolvency representative. This is also another option which has been discussed. And also, this actually, when we talk about recognizing foreign representatives as a distinctive class of professionals, this could potentially exempt foreign representatives from the restrictions applicable to foreign lawyers practicing in India. Also, facilitating access through uh, domestic insolvency representatives, then the foreign representatives could work in conjunction with Indian insolvency professionals, allowing them to indirectly access courts and exercise their powers. Even the committee suggests that IBBI could define a code of conduct for foreign representatives. It also proposed that the penalty provision similar to that applicable to the domestic insolvency professionals should also be made. The committee also said that the access to foreign representatives uh, should have the following considerations. One, balancing the model law's principle with Indian legal framework, phased implementation, and flexibility and adaptability. the committee recommended that this should be a very, very gradual approach, advocating for a measured implementation of the model law provisions, particularly those concerning direct access. It should be, and secondly, whatever we make, that should be flexible, and the flexibility can be achieved by giving powers to uh, the regulator. So that's what the recommendation by the committee. And then we also see that the foreign representatives, even if they are allowed the necessary powers and ensuring accountability within the Indian jurisdiction, and in fact, some regulatory measures were also proposed by the Insolvency Law Committee. That was limited jurisdiction, so they should not have jurisdiction beyond whatever is defined in Part Z, which is supposed to be implemented, and also the code of conduct and penalties that should be made, but that should be restricted to the powers that they have been given. And the uh, registration with IBBI, that can also be considered. So in fact, there are in the, when the committee was made for forming rules and regulations, even the form was proposed. A fee of 10,000 was also proposed for any foreign representative to register with IBBI. See, in this committee also recommended that Article 10 in the draft Part Z of the IBC, and suggested that the foreign representative should be subject to the code of conduct. Penalties similar to the domestic insolvency professionals and potential registration with IBBI. So this provision, adopted by the countries like US, UK, and Singapore, aims to prevent excessive jurisdictional claims while still allowing penalties for misconduct. Like, even it is proposed that the obligations and penalties for foreign representatives should be proportionate to the access granted and decided through subordinate legislation by the central government. So in fact, when we see, there are a lot of things which are supposed to be made, because there are in the committee have recommended at various places that the it should be regulated through the regulator, or it should be regulated by the central government, or some kind of guidelines would be available for the adjudicating authority. So there are many such regulations, many such rules, and many such guidelines are in fact anticipated in this recommendation of ILC, which is still to be done. So in fact, lot to be done for implementing cross-border insolvency, but the committees have recommended that it should be implemented as fast as possible. Now, when we say participation in proceedings under the code, that is again for the foreign representatives to participate in insolvency proceedings under the code, subject to the manner of access determined by subordinate legislation. And the report, in fact, advises against granting foreign representatives the power to initiate insolvency proceedings in India. In fact, the foreign creditors have already got a power to initiate any kind of insolvency process in India as a foreign creditors. So therefore, the creditors can initiate, but the foreign representatives should not have power to initiate insolvency proceedings in India. So this actually something which is very important, that the insolvency cannot be started by the foreign representatives. However, it can be started by the creditors directly. So in India presently also, no insolvency professional or no lawyer can initiate the uh, proceedings, insolvency proceedings against a defaulter. It is to be initiated by the creditor only, and not by the lawyers or any. Now, we move on to the subject, which is access of foreign creditors to proceedings under the code. So far, the foreign creditors have rights to start insolvency proceedings against any Indian company, and they have the same rights to start. And what this access to foreign creditors is considered, they're saying that they, in fact, are able to, they are able to uh, uh, commence their they are able to initiate the insolvency process already. So there is nothing else is required. However, this particular power that they have got as a creditor of the Indian company, even if the creditors are located anywhere in the world, but they have the power to initiate the insolvency proceedings against any Indian company. However, this particular power is having some exclusions. And what the exclusions are, that in case there is any demand of foreign tax which is outstanding, or if there is any demand for social security claims, if that is outstanding, that would not be considered as a valid initiation of the insolvency process, because the foreign tax and the social security claims are not an Indian issue. They actually can recover their money in other ways. However, the foreign tax and social security claims cannot be used as debt, and that cannot be used as outstanding from the company, and that cannot be even used as a reason for starting insolvency. Now, secondly, like the foreign creditors claim, the committee suggests that the foreign creditors should not be having any kind of unfair disadvantage. They should be dealt with at par with the domestic creditors, and they cannot go to below the clause F of Section 53, subsection 1. Foreign creditors cannot go beyond this, because they actually have to stand as per their as per their as per their entitlement. If they are financial creditors, they would stand shoulder to shoulder with this financial creditor. In case they are secured creditor, they would actually stand shoulder to shoulder with the secured creditors. However, any foreign creditor would not be below clause F. So that is something which is at par with the operational creditor. So that ranking should be equivalent to the domestic claimants, domestic creditors. This is what is the recommendation by the Insolvency Law Committee. However, a problem was felt that in case there is any initiation of insolvency of a company, how the foreign creditors will get to know about the insolvency commencement and their requirement of filing a claim. In this manner, because see, the public notice that we are supposed to give in two newspapers, one in English and one is in vernacular language, those notices may not be accessible to foreign creditors. So therefore, the committee recommended that there should be a clear and accessible notices to the foreign creditors. However, it is restricted to the known foreign creditors. If it is not known to the RP, then it is no way possible. However, there should be, if there are known creditors, foreign creditors, they should actually be sent individual notices for filing their claim. Also, the IBBI notice or IBBI website can be used, or company's website can be used to say that all the creditors are supposed to file their claims. So that is the requirement, that how to reach out to the foreign creditors for submission, for inviting their claims. So therefore, the committee recommended that there can be something which is the notice, special notice has to be given to the foreign creditors. Now we move on to another subject, which is the recognition of a foreign proceedings and a relief. So application for recognition. The model law, in fact, empowers that the foreign representatives to apply for recognition of foreign proceedings in other countries. Now, the report also says that the specific documents are required for applying for the recognition in India. Now, suppose there is an insolvency which is started in USA, and that particular company has some assets or some businesses in India, then the first requirement is that they would apply. The representative will apply for recognizing in India, for a recognition in India to the foreign proceedings. So therefore, the document which are supposed to be attached is the proof of foreign proceedings, certificate of appointment, statement of pending proceedings, and English translation in case the documents are made in any other language. Now, the report also presumed the authenticity of documents by the foreign representative, dispensing with the need for legalization. That's what we said, that the apostolization or the notary requirement, that also would not be required once the uh, cross-border insolvency is notified, with all these provisions, that this Article 16 of the model law would be adopted by Indian government, so that there is no requirement of apostolization of documents, and also for notarization of a document for getting admitted in India or for getting recognition of that document in India. So therefore, the that's what is the regarding our uh, recognition of a foreign proceedings and reliefs. Then we would be discussing in our coming slides that what are the kind of reliefs. That could be interim relief, then it can be automatic relief, or it can be a relief which is mandatory. So these are the kind of reliefs that we will discuss once the commencement of the uh, commencement of insolvency proceedings uh, is done. So Ankit, I have to move on to the 𝐄𝐚𝐚𝐢𝐥, which is Center of Main Interest. So there are this subject is slightly ticklish, and it is a lot of things have been recommended by the committee, which is making, or which has recommended some rules and regulations. So anything that you would like to add into this subject, and specifically how important this subject is for the audience when it is not yet implemented, and the government is doing a lot of work, but a lot of work is still to be done.
I think it is important for the professionals as far as finding, like it's not really the subject that this cross-border insolvency is not really talking about, or not really dealing with the idea that how Indian insolvency professionals can actually find opportunities abroad. Because in case we look at other professions like chartered accountancy or others, many people who are into those professions today are exploring opportunities abroad. So that's one that I believe all professionals will be interested in. Because when it comes to, as I said earlier also, when it comes to an entity having interests in multi-country, corporations, in India, we somehow have structures which are dedicated to the Indian businesses. The idea that an Indian business will have a foreign branch or a foreign asset someplace is there, but then of course it's not that prevalent per se. That's maybe the only limitation with respect to cross-border insolvency that I also pinned in the previous webinar. So this is what my thought is.
Good. I think we can move on to this very important subject, which is 𝐄𝐚𝐚𝐢𝐥 and Center of Main Interest. That means there where the main proceedings will continue, and all other uh, proceedings will be non-main proceedings. So therefore, the 𝐄𝐚𝐚𝐢𝐥 is very important, and the model laws, in fact, says that the 𝐄𝐚𝐚𝐢𝐥 is required to be determined as main proceedings, which is accorded as a greater deference. So the model laws, in fact, says that the 𝐄𝐚𝐚𝐢𝐥 should be uh, should be the registered office of the uh, debtor. If the registered office of the debtor is in USA, that should be the center of main interest. However, when the Indian committee was drafting the regulations and rules, they have given a lot many other uh, factors which will determine the COMI for the company under insolvency process. Now, Indian the Insolvency Law Committee felt that in case we only refer to the registered office of the company, and that particular clause can be abused by forum shopping, means by shifting the registered offices to other friendly countries, and therefore the it is not only registered office which is recommended by the Insolvency Law Committee. Then the uncertainties and the factors to rebut the presumption that the debtors registered office is COMI or not COMI, those factors are also uncertain. So, in fact, the committee has recommended certain factors which the adjudicating authority will consider while determining COMI of a company. So, those uh, guidelines will come from central government, and those guidelines will be helpful in determining COMI. The model laws, in fact, uh, uh, also does not provide for a mechanism for determining COMI of an entire enterprise group, So they talk about individual companies, but they are not considering the uh, entire enterprise group uh, COMI. So they are saying that it should be aligned with the COMI of entire enterprise group and not for the only company which has gone to the insolvency. That is also the recommendations of the committee. Now, committee also recommended that a look back period of 3 months should be considered, and any change in the registered office from one country to the other country that can be ignored by the adjudicating authority, and therefore the COMI can be determined by the adjudicating authority, which is a place other than the registered office of the company. In fact, the two main factors which the UNCITRAL guidelines has actually been given, that is the uh, location that is readily ascertainable by creditors. So therefore, the code or insolvency law committee says that the adjudicating authority should be getting some kind of guidance from the central government regarding the issues of determination of COMI for each corporate debtor. Then in fact, the central government has been empowered through this Part Z that they would make subordinate legislations and providing a list of additional indicative factors for determining COMI. And that actually will become challenging. But yes, there is no other alternative. Simply the register office of the company that can be abused by shifting the register office to a very, very friendly country. So then the promoters can actually avoid from various kind of fraudulent activities that they have done. So now, once the we have discussed about the foreign representative, we have also discussed about the COMI. Then comes is the decision of recognition. The recognition to the foreign proceedings in enacting country. Like recognition of an insolvency which started in USA needs to be recognized in India by a court, then only the powers of those uh, representatives that would be effective in Indian jurisdiction. That's what is my understanding. Then the foreign proceedings can be recognized as either foreign main proceedings and foreign non-main proceedings. And there are challenges. There are no time limits for the adjudicating authority to decide an application for recognition. In fact, the uh, adjudicating authority will have to decide. That is the recommendation of ILC, that the insolvency committee has to define a 30 days period, has to recognize or reject within 30 days period of the application. So like when our team is studied further, they could see that in the case of Lehman Brothers Holdings in the year 2008, uh, the Lehman Brothers Holding Incorporated was headquartered in the United States but had operations in multiple countries. So in that case, the during the proceedings, the primary insolvency proceeding was initiated in New York. It's 𝐄𝐚𝐚𝐢𝐥, that is its 𝐄𝐚𝐚. Then, at the recognition, the court of UK and Germany and other jurisdictions recognized the US proceedings as a foreign main proceedings, and therefore, what we are saying is foreign main proceedings and foreign non-main proceedings. Foreign non-main proceedings are which are although associated with the main proceedings but are not the part of the main company. That is what is the foreign non-main proceedings. Then we also have seen in the case of Jet Airways that the Jet Airways, in fact, it was an Indian airline and had a registered office in India, but also had operations in Netherlands. So, in fact, during the proceedings, the primary insolvency proceedings were initiated in India, and it was making it foreign main proceedings in other jurisdiction. Foreign main proceedings in other jurisdiction. So this is the recognition. The Dutch bankruptcy court, in fact, the Dutch bankruptcy court initially considered in Dutch operations as a special proceedings, but later the Indian proceedings was accepted as the main proceeding and the foreign non-main proceedings. So this is all a kind of definition that we have. So this is something which we can avoid just to see the end of the subject today. Now, moving forward, we have already discussed that the recommendations of the committee regarding the 𝐄𝐚𝐚𝐢𝐥, and now we talk about the reliefs. In fact, there are many reliefs under the insolvency. One is the interim relief and a relief on recognition. So there are many relief which are given to the company on recognizing in the country as insolvency. And in case it is not recognized by the, like, for example, the US company is under insolvency and they immediately would like to come to India because that company has assets or subsidiary companies in India. Therefore, they would immediately seek a relief. So the government will say that we will grant you the relief, we will give you the immediate stay on the uh, uh, assets of the company or the business of the company. But that's what, but then we would actually first assess whether the proceedings can be recognized in India or not. So the recognition in India is very important. Then only they can ask for interim relief or relief on recognition. Now, interim relief, in fact, means that the relief that may be granted by the court after an application for recognition is filed, but before court makes a decision on recognition. In another case, the committee also noted that Article 19, the model provides urgent relief, including staying the execution of debtor's asset. However, IBC does not currently empower adjudicating authority to provide interim relief during the CIRP. So therefore, the same provision is likely to be implemented for even cross-border insolvency. So based on this, the committee recommended that the interim relief should not be included in Part Z, as it may lead to some confusions. Then comes is the mandatory relief and discretionary reliefs. I will explain you with the examples. So what are the kind of reliefs? So when our team studied, they could find that in the case of Three Arrow Capital in 2022, in fact, the Three Arrow Capital Three Arrow Capital, it is a fund, a cryptocurrency hedge fund, filed for insolvency in the British Virginia Island. And they asked for some relief, and that relief was that the US bankruptcy court issued an interim order under uh, Chapter 15, freezing the company's US assets to prevent dissipation before full recognition. Similarly, in the case of Lehman Brothers in 2008, the UK court order was that before recognizing Lehman Brothers' US bankruptcy, the UK court issued an interim order to prevent assets uh, from transfer. So the reliefs were granted uh, in these cases. Now, a relief on recognition. So automatic relief, like in case the proceedings are recognized in a country, then there are some automatic relief, that is the relief on recognition, like Section 14 in our case. And in the case of Jet Airways, the Jet Airways, in fact, insolvency was started in India and the parallel process was filed in Netherlands. And then the relief granted on recognition in India, that means the uh, recognition was allowed, and automatic stay on legal proceedings against Jet Airways in India was also imposed. Prevention of asset disposal by the creditors was also involved. And our team further studied that in the case of Ocean Rig in 2017, US recognition of Cayman Island proceedings was done. And when these reliefs were granted, one was the automatic relief and the other was suspension of US liquidation order. So those were the relief granted. Now, when we talk about the mandatory relief, mandatory relief is covered under Article 21 uh, of the uh, UNCTRAL model. Uh, so therefore, that is the mandatory relief which is immediately after the recognition is granted to the foreign proceedings. And the examples that our study team has found regarding ENRC Limited, and that was in 2020, UK recognized the Kazakhstan insolvency. UK recognized the Kazakhstan insolvency, and in fact, Kazakh mining company underwent insolvency in Kazakhstan and sought recognition in UK court. And the relief which was actually granted, that the UK court ordered the turnover of UK-based assets to the Kazakh insolvency estate, freezing the bank account of the to prevent withdrawal. So that kind of examples that we are trying to find regarding mandatory and discretionary reliefs. Now, on recognition, when a case is recognized, in India as a main case, which is actually started in an overseas, started in any other jurisdiction, the committee also deliberated to the automatic moratorium provided under Article 20 of the model law. The moratorium applies upon recognition of foreign main proceedings, similar to the domestic moratorium in the enacting country, and does not interfere with domestic insolvency proceedings or the filing of claims. Now, the model law, in fact, gives the adjudicating authority broad discretion to modify or terminate relief, which could be problematic. The recommendation of the ILC in this case was that the adjudicating authority's power to modify or terminate a moratorium by ensuring it mirrors with the moratorium and exceptions under the Indian bankruptcy law. So therefore, it was recommended that the discretionary relief and the mandatory relief that should be given to avoid any confusion. The committee recommends adopting the provisions of model laws on cross insolvency, especially Article 19, which provides for urgent relief, and Article 21, which provides a discretionary relief and Article 22, which is flexibility to modify, terminate, relieve any indication of the Indian lawsuit. So, Ankit, can we see some questions?
So we don't have any questions that I can see that have been raised by anyone. And I think we can
You
move
can
forward.
add something
Rather,
on.
rather in case somebody wants to say something about this subject, maybe they can raise their hands. And alternatively, what we can do is we can also you can request you to post some questions that you might be having.
So in the meantime, we will actually quickly go forward relief on recognition, because there are various types of reliefs on recognition that can be granted. Then in the case of avoidance transactions, also the model law presents that there are some challenges in the legal system, particularly when determining the effective date for avoidance actions in cross-border case. And the recommendations, in fact, by the committee was adopting Article 23 of the model law as it is, with the understanding that the domestic policy and the conflicting law of conflict of law rule will determine the applicability of the avoidance transaction. So the and see, we can also briefly touch upon the cooperation with the foreign courts and foreign representatives. Now, this cooperation is definitely a part of the model law, and that the cooperation between the courts is necessary for faster kind of solution. Even uh, common hearings are also proposed, and although it was noticed by ILC that the Indian adjudicating authority does not have experience in communicating with foreign courts regarding cross-border insolvency, and therefore they may require additional infrastructure. And in this case also, the central government should issue guidelines in consultation with the adjudicating authority to guide cooperation and communication between adjudicating authorities and foreign courts in the early stage of the implementation. And also it is recommended that the adjudicating authority should also have the joint hearings if possible in some cases. Now, when we talk about the concurrent proceedings, I have some examples of concurrent proceedings. In the case of Lehman Brothers in 2008, UK domestic proceedings, in fact, uh, the originally the insolvency was started in the USA. USA court recognized the USA insolvency as the foreign main proceedings, and the domestic proceedings were also initiated uh, in UK, because see, it was initiated in UK because it company has separate UK insolvency because of the various assets that it has in UK, and the UK High Court initiated administration proceedings for Lehman Brothers, uh, and then under the UK Insolvency Act. Similarly, in the Airway case in 2019, although it was the 𝐄𝐚𝐢𝐥 was in India, however, the Dutch creditor initiated separate insolvency proceedings in the Netherlands. So they actually did that. They in fact did the separate insolvency proceedings. And then in the case, so that was based on the 𝐄𝐚𝐢𝐥. In the case of Hanjin Shipping in 2016, it was US also started proceedings, whereas originally the proceedings started in Korea, and the US has started their proceedings in US bankruptcy court. And this is what actually we are trying to say, that the concurrent proceedings can be started. And in the case of concurrent proceedings, there has to be a modification in the relief. In case any relief or any recovery is made by any creditor, the creditor will immediately convey it to the other part of the process and will accordingly reduce its claim. And then we reach out to say that the coordination with the multiple foreign proceedings. That is also, we actually have seen that there are, one is the hodgepodge rule. Hodgepodge rule says that if any creditor has recovered any money from any proceedings, maybe main or non-main, he will inform, and accordingly his rights will be uh, shrinked. His rights will be accordingly uh, curtailed to the extent of the recovery that he has already made. So it's a hodgepodge rule that if you recover from any side, from any source, it is a hodgepodge, and then you have to reduce that amount which has already been recovered. So that is something which is important, and of course this also matches with the Indian laws. So then we also have seen uh, that this committee was constituted, the Committee of Cross-Border Insolvency Rules and Regulations Committee, which is CBIRC. CBIRC was constituted in January 2020 for the purpose of drafting rules and regulations on cross-border insolvency. And it actually gave a report and recommended that the uh, this law, cross-border insolvency law, is very important. In fact, very next month, this particular committee was also made uh, uh, responsible for developing a group insolvency or enterprise insolvency, enterprise group insolvency. So that also, in fact, they tried to make some rules on this also. And not sure when it will be implemented, but this cross-border insolvency rules and regulation committee, in fact, gave its report on 15th of July 2020, and it was published by IBBI also. So while making the rules, in fact, the Insolvency Law Committee uh, has been, uh, some of the recommendations of the Insolvency Law Committee was changed while this particular committee was making rules and regulations. So therefore, I said, till the time final, therefore, I said, till the time final uh, is not released, the rules or regulations are not released, or amended form F, amended part Z is not released, it is very difficult to say that this law is actually implemented. So that actually is not happened. So in this important part is the communication. When this particular rules and regulations were being made, one subject came up regarding the communication and cooperation between the adjudicating authority and foreign courts. So therefore, this particular committee recommended to adopt JIN, that is Judicial Insolvency Network guidelines. And it actually, this particular guidelines provide a framework for cross-border cooperation and communication between courts handling insolvency matters in different jurisdictions. Then the guidelines for cooperation and communication between adjudicating authority and foreign courts with the modification from NAFTA. NAFTA is the North American Free Trade Agreement, and the EU, European, the European Union guidelines on cross-border. So the proposed draft notification says that the central government should notify uh, guidelines for communication and cooperation between the adjudicating authority in India and with the foreign courts. These guidelines adhere to Part Z and of the code in its own rules. So when we talk about this different organizations, one is the Judicial Insolvency Network, and the other is NAFTA, which is North American Free Trade Agreement, and then is the EU guidelines. In that case, automatic recognition of foreign order in judicial network, it is no. NAFTA also says no, but the European EU says yes. So the Indian concept says that no, but case to case basis it will be decided. On case to case basis it will be decided. Then comes is the court to court communication. Court to court communication is in fact recommended as per JIN guidelines, JIN, and it is also recommended by the court to court communication, like by European Union also it is recommended by yes, and in Indian modified approach it is again said yes. Use of cross-border protocols, it is yes. And NAFTA says limited, but EU guidelines say yes. In India, it has already been adopted in the case of Jet Airways. Then foreign creditor treatment in the case of GIN and guidelines, it is equal, and for NAFTA it is limited, and EU guidelines equal, and in India also it is equal. Joint hearing, it is encouraged, but NAFTA doesn't encourage, but in EU guidelines it is allowed, and uh, in the document which is published by the Insolvency Law Committee, it is said that the equal rights with the Indian creditor priority. Joint holdings, also it is allowed via video conferencing between the courts, and public policy safeguard, everyone says yes, that you have a right to uh, safeguard your interest. So there are, in fact, various rules and regulations have been made by the committee, which is CBIRC, and that committee has made various rules, but it is not really the time to discuss all rules, because whenever these rules will be notified, we would be discussing the rules. Even forms are also made in some cases, but we only have to see what exactly was done by the 32nd report of Standing Committee on Finance, which is from Ministry of Corporate Affairs, and that was released in August 21, and their observations were there. And finally, this particular report was again kind of modified by the 67th report on the Standing Committee of Ministry of Corporate Affairs. And in that 67th report, even 32nd report was also considered. The observations of the committee was effective resolution through of cross-border insolvency requires enhanced coordination and communication between jurisdictions. The committee also recommended expediting the adoption of the cross-border insolvency framework under the IBC, and the committee also recommended, like in fact, all this was published, comments were asked for, but then finally, the it was it is under implementation as of now. So this is what we have for part 3 and the final part on cross-border insolvency. We have studied even the regulation by regulation, but not that everyone will have interest on a regulation by regulation law on cross-border insolvency. So Ankit, this is what we can conclude, and in case there is any person who would like to add anything, we can take him also.
I'm not able to see the attendees today for some reason. Do you see any attendees raising their hands?
Yes, I can see the attendees, and I can see this
Them to
Ranjan's can simply say in case he want to say something. Ranjan's, am I audible to you?
Yes, sir. Am I audible, sir, now?
Yes, yes.
Sir, in one case, sir, can a resolution plan involve a scheme of amalgamation, both with Indian and foreign entity, subsidiary to the SRA?
Again, I think what you're saying is that the can a resolution plan can be coupled with a scheme of compromise or arrangement under Section 230.
Yes, and both with Indian and foreign entity, subsidiary to the SRA.
No, the Indian and foreign entities subsidiary to SRA is not significant. See, any person can come and take over a company in India, whether with the subsidiaries or without subsidiaries, it is not important. It is open because no license is required for any foreign company to come and do business in India. So they can also buy shares of the companies. So that is what, so there is no restriction. And the second part is that in during resolution plan, whether the Section 230 compromise or arrangement scheme can be implemented. According to my understanding, yes, it can be implemented, but however, we'll have to just take care and that the bench should agree for this, and bench should, in fact, continue the moratorium period uh, till the time this resolution plan is approved. And it is possible because see, it is the under Section 230 of the Companies Act, there is a separate part of that section, which only deals with the corporate debt restructuring. So in that corporate debt restructuring, whatever conditions are there, that has to be fulfilled, and the all the creditors and the total creditors of the company, they'll have to vote, even if they are operational creditor. So that is possible, Ranjan.
Another question, sir. So, what would be the tax effect of debt written off after resolution of Indian company in case of both Indian and foreign debt?
And if the company is accessible in India, and then any liability which is ceased to exist, or the obligation is completely uh, uh, washed out by the resolution plan, then that will be taxable under Section 41, subsection 1 of Income Tax Act, and also Section 28, subsection 4 was in fact the it was modified by the uh, by the government, and then uh, so this also attracts tax. But in most of the cases, we find on the asset side that there are assets which are not exactly recoverable or existence. So that also can create some losses to set off the gains, which is out of Section 41 and 28.
Yes, sir.
So
Thank
we
you.
can discuss this particular issue. Is a very, very large issue, how to make a resolution plan which is tax friendly. Otherwise, there are a lot of people that are struggling after a resolution plan is approved. How can they safeguard themselves for from tax liability? So this is all, Ankit, from us. I think should we close it?
Thank you, sir.
Yes.
All
So
right.
thank you very
So,
much.
thank you, everyone. Thank you so much.
Thank you. This is our way of learning. Thank you.